Good afternoon, NEA members. I am Becky Pringle, Vice President of the largest labor union in this country. On behalf of Lily, our President, and Princess, our Secretary Treasurer, I want to thank you for joining this call this afternoon. You know, the fact that we had close to 20,000 people RSVP for this webinar and another 20,000 who joined us last week tells me there is a real need for good information and guidance on how best to start the school year right. The decisions about when and how to open schools are ones that the National Academy of Science has accurately called the most complex and consequential of the COVID-19 pandemic. Yet those decisions have largely been pushed down to the state and often to the local level, where school districts and institutions of higher education with vastly different resources are struggling to make decisions that are best for our students and our members in our communities. And we know that the deep inequalities throughout our school systems mean that our school districts with the fewest resources and the greatest need will face the most daunting challenges. That's why NEA has called for reopening plans that are centered in equity, that are grounded in science, and that are always rooted in ensuring that every student, everyone in every school receives a quality public education, whether it's remote or in person. I know how deeply you care about your students. I have been listening to stories from members all over this country. I know that you are eager to return to your classrooms to be with your children. But the critical foundation for any and all reopening work must be the health and safety of our students and our families and our educators. And this is not a partisan issue. There is no Republican or Democratic way to proceed to keep our students and our communities safe. We need to listen to and understand what the scientists are saying. And we need to reopen our school buildings when they say it is safe. And then in collaboration with us, the educators, we need to determine the way that is best to reopen our schools. No one should be politicizing this crisis. And Donald Trump and Betsy DeVos's attempts to do so have been and should continue to be rejected by any and everyone who cares about our students and our communities. When you listen to the scientists and the healthcare professionals like pediatricians, what they are saying is that if and when schools reopen, they will need massive new funding to do it safely. We know that putting the protections in place for our students and our schools to be safe and to create those environments that are safe for teaching and nurturing our students will be incredibly costly. We also know that the economic crisis caused by this pandemic has wreaked havoc on school and college budgets throughout this country. It has already resulted in the loss of nearly 1 million educator jobs and has put another 2 million more at risk. I don't need to tell you, the folks on this call, that our public schools have yet to return to the funding levels from before the 2008 financial crisis, when more than 300,000 school employees lost their jobs because states decided to balance their budgets on the backs of our students. You've been living that reality for well over a decade. Honestly, it's why tens of thousands of you rallied and marched in Red for Ed movements all over this country. So you know we can't possibly bring students safely back to the classroom if we don't get the support we need from the federal government. And you know, I'm specifically calling out the White House and the US Senate because the House of Representatives has already passed the HEROES Act, which allows for hundreds of thousands of educators to remain on the job and continue to serve our students. It would give our schools the necessary resources and protections they need to put in place. But the Senate has still refused to act. So we need you and everyone who likes you or loves you or intends to keep living with you to contact your senators and demand that they support our students by passing the HEROES Act. All it takes is a quick visit to NEA.org/COVID action to add your voice to our collective effort to get our students and educators what they need and what they deserve. As I plan to hand off to NEA's illustrious, brilliant General Counsel, Alice O'Brien, to kick off the presentations by our attorneys and the collective bargaining and member advocacy teams, let me end where I began. Thank you. Thank you for making me so proud to be an educator, a unionist, and an NEA member. Thank you for standing up for our students and our schools and our colleagues and for this country. And know we are standing up for you. Alice?
Thank you so much, Becky. And hello, everyone. I'm Alice O'Brien, NEA General Counsel. We are going to cover a lot of ground today because we know you have many, many, many questions. In fact, over the last 2 weeks, we have had almost 9,000 questions submitted to NEA by members registering for last week's town hall and this week's town hall. And we have crafted the agenda for this call to answer as many of those questions as we possibly can. And after this call, you will be getting emails from us with more resources, providing more detailed answers on those questions. And you can also go to educatingthroughcrisis.org for further resources as well. And you can also, if you haven't already, join the Facebook NEA Navigates COVID-19 group, where you can reach out and collaborate with other educators across the country over these school reopening issues. We know that today our country faces an incredibly difficult time, and the decisions around school reopening, as Becky said at the outset, are among the most complex and consequential that our country has to navigate. So today what we want to do is provide you with some basic information about your rights and about the recommendations for school reopening from the health and science experts. So you have the best information in front of you as you navigate these issues. Now, I have to start out by saying what we're going to talk about today is of necessity general principles. And if you're looking for specific advice, you always need to go to your local chapter affiliate or your state affiliate. And they will be able to assist you, provide you with access to representation on your needs. So today, this afternoon, we're going to talk first through the health and safety recommendations. We'll also talk about accommodation and leave rights. We'll talk about worker compensation and waivers, and bargaining and advocacy for safe schools. On the call with me today are 4 of our resident experts on these issues: NEA Collective Bargaining and Member Advocacy Director Dale Templeton, NEA Deputy General Counsel Jason Walta, NEA Staff Attorney Kira McNett, and NEA Collective Bargaining Specialist Marcy Magid. I'm going to start off the agenda on health and safety, and then turn it over to Kira, who will talk about accommodations and leave issues. Jason is going to then address waiver issues, liability issues. He will then turn it over to Marcy and Dale to talk about advocacy strategies, both through bargaining and other avenues for making sure that our schools reopen safely. Before we dive into all that, I want to give Dale a chance to introduce herself too.
Thank you, Alice. Good afternoon. I'm Dale Templeton, the Director of Collective Bargaining and Member Advocacy at NEA. Thank you for joining us today and for all the work you do for our children every day, but especially now during these challenging times. Prior to coming to NEA 7 years ago, I spent my career working for our affiliate in Maryland, advocating for our members. As Alice said, we know that you are deeply concerned about what opening schools and in-person instruction will mean for you and your students. But we hope that the information you take away today will help alleviate some of your concerns. For all of us, COVID-19 poses unprecedented challenges, and the way we address those challenges will vary from state to state and district to district. And we promise that we will continue to do everything we can to support your local, your state affiliate, and you, our members. And I'm going to turn it back over to you, Alice.
Great, thanks so much, Dale. So we're going to begin with what has to come first in this crisis: the health and safety of our students and our staff. NEA's position has been and remains that the absolute preconditionings for reopening are, number one, a scientific consensus that the virus has been sufficiently contained in the community, and that the local health infrastructure can address current and future outbreaks. And number two, a plan in place to continue to contain the virus. Those criteria are not met in 44 of our states. We did this town hall last week, and at that point it was 43 states, but the numbers are trending poorly almost everywhere in the United States of America. The boxes on your screen represent individual states, and the trend lines are daily new cases per 100,000 people. In all 44 of the orange shaded states, the trend line is up, meaning cases are increasing. What that means in terms of CDC's overall criteria for reopening is that that says 43, but that's from last week, 44 states fail the threshold CDC criteria. And that's only one of the 6 criteria that the CDC has put on states moving forward with reopening everything, not just schools. Now, in contrast, people often point to the EU countries and they say they reopened. Why can't we reopen? Well, first of all, the EU countries overall had far lower community transmission rates in their experience with the pandemic. And secondly, they reopened schools only after transmission was down. So you can see 2 examples on the screen, but there are more. And the trend lines there, again, are daily new cases. The first arrow pointing down is when school reopening began. And the second arrow in the case of Denmark is when they rolled into school reopening. Initially, they opened only the earliest elementary school grades, and under very strict protocols, class size limits of 10 to 12 students, hand washing mandated every 2 hours, strict protocols. And only after they continued to have a downward trend did they open the upper grades. Germany, more variation in terms of the precautions that were taken upon reopening, but again, reopening only occurred once there was a substantial downward trend in cases. In contrast, Israel initially had a gradual reopening, focused only on the lowest grades. You can see that purple arrow pointing down. And under pressure, the Israeli government then did a general reopening, abandoned a mask requirement, and as a consequence, 2 weeks later, there were outbreaks in the schools affecting more than 200 students and staff. And subsequent to that, a second pandemic wave in the country, which public health officials have pointed to the school reopening as one of the factors in that second wave. So step 1 in any safe reopening plan is the pandemic has to be under control. That's step 1, non-negotiable. Step 2 is once it's under control in a particular area or community, the protections need to be put in place in collaboration with the educators to contain the virus successfully going forward. And the CDC has very detailed guidance as to how this should be done. which we recommend that all states and school districts and institutions of higher education follow. The CDC guidance has 3 overriding considerations. Number 1, the CDC calls for students and staff who are high risk, and we'll talk in a little bit about who those categories are, should be provided the options to telework or to do distance learning in order to protect them. Number 2, the CDC calls for schools and campuses to put the basic protections in place to prevent the spread of COVID-19 and to detect its spread and quickly respond if there is any outbreak in the school. And number 3, to make sure students and staff can stay home if they are sick and that they are encouraged to do so. So what are these CDC precautions? We call them the 4 Ds: distance, deterrence, disinfection, and detection. And we'll walk through those. But they are all important, and they work together in a complementary fashion in order to limit opportunities for the transmission and spread of the virus in schools. So physical distancing recommendations. The CDC calls for students and staff to be 6 feet away from each other. You know, this applies not just to students, but to staff in the teacher's lounge as well, and staff in the central office as well. So seats and desks need to be at least 6 feet apart. Large group outings need to be canceled. Non-essential visitors need to be kept out of the school. Communal spaces like dining halls and playgrounds need to be closed or their use severely reconfigured in order to limit the number of people who are using them at any one time. Drop-off patterns, arrival patterns, class passing patterns need to be addressed and reconfigured in order to limit the number of people that any staff or any student comes in contact with over the course of the day. And of course, school buses are a big, big deal. The CDC calls for school districts to create distance between students on school buses as well. The deterrence recommendations are straightforward. They're things that educators have been telling their students forever, but ramped up to a significant degree. So hand washing, proper cough and sneeze etiquette for all students and staff, face coverings for all staff and strongly encouraged for all students, adequate supplies for hand washing throughout the schools and limiting the opportunities for high touch surfaces throughout schools and campuses, ensure ventilation systems operate properly and bring in as much outdoor air as possible. Open your windows if you possibly can. Open the windows on school buses. Make sure that HVAC filters on school buses work and bring in as much outdoor air as possible. Disinfection recommendations, also pretty straightforward. Clean and then disinfect. Clean and disinfect frequently. Touch surfaces daily. Clean any shared objects, manipulatives, art supplies, tools, games between uses. And of course, always ensure the correct application of disinfectants and keep the products away from children. The CDC detection recommendations are, if it's feasible, conduct daily health checks, temperature screening, symptom checking of staff and students while maintaining confidentiality, complying with the privacy rules, and also encourage both students and staff to stay home if they are sick. Now, the CDC recommends if, as a result of that screening, the school finds or the campus finds that there's someone on campus that has COVID or has COVID symptoms, they should be isolated. A procedure should be in place to get them home or to a medical facility quickly and safely, that the local health officials be notified, as well as staff and families who have been exposed to that individual, which is really important. So the CDC recommendation, which your local reopening plan should follow, is that staff and family members be notified if there is a COVID case in a school. The area where the sick person was should be closed off You should wait at least 24 hours. That's to try to reduce the viral load in that area, and then clean and disinfect it before anyone uses that area. Sick staff members and children shouldn't be told that they should not return until they meet the CDC criteria to discontinue home isolation. And everyone who is in close contact with that individual should be told to stay home and self-monitor for symptoms. And Kira's going to talk in a minute about the leave possibilities for if you're ordered by your employer to do that. The CDC says that when state and local health departments advise that schools be closed because of increased community transmission rates, that should happen. And that schools also should be closed if there is an outbreak in the school and that it's determined to pose a risk of a community outbreak as well. So a couple of things on the 4 CDCs. Number one, they're very self-explanatory and very intuitive. They're also very expensive. They will be very expensive for schools to meet. And we know that our school systems have deep inequalities throughout them. And we also know that the deep inequalities in our school systems are confronting a pandemic, which has had devastating impacts on our African American communities, Native American communities, Latino, Latinx communities. And so it is critical in school reopening plans, in making sure that all these 4Ds are addressed, to make sure they are addressed in all schools, and existing inequities are dealt with in school reopening plans. Otherwise, the school reopening moment will exacerbate the inequalities in our society rather than improve them. It's also important to know that the 4 CDCDs work in conjunction with each other. And if they're not all in place, if schools just reopen without the precautions in place, the predictions of experts are that outbreaks will occur much more swiftly than they will if the overlapping protections are put in place. So for example, there was a study out of Pennsylvania done by the Pennsylvania Department of Education, which predicted based on a number of assumptions. So you should realize that this is a prediction. It won't necessarily come to pass everywhere, and it's based on a lot of assumptions that may not be true everywhere. But without safety precautions, the average school in Pennsylvania would have 5 infections within 5 days of opening. But if all the precautions were put in place, the length the school could reasonably be expected to stay open could be increased 10 to 15 times. So the key takeaway here is just the difference between how long you can reasonably expect a school to stay open based on the level of precautions that are put into place. Now, we've been talking about the CDC, but the other experts uniformly agree. The American Academy of Pediatrics has come out strongly in support of safe reopening and come out in opposition to reopening when transmission rates are such that local health authorities object to school reopening. This is a July 10th joint statement by AAP, NEA, AFT, and AASA. The National Academies of Sciences, Engineering, and Medicine support reopening only when safe as well. They also recognize that significant new federal funding is necessary. So write your senators and get all your friends to write your senators to call on the federal government to provide the funding which is necessary to do this safely. And they call for even more rigorous health and safety protections than the CDC, including that all students and staff should wear face masks. Some states have established health and safety requirements for schools through executive order. So what we've been talking about so far are recommendations from the CDC, recommendations of experts. And the task at hand now is to get those recommendations into the form of mandates for school reopening, either at the state level or at the local level. Our state affiliates have done have been working at this and have been successful in a number of states. So for example, in Michigan, the Michigan governor has issued executive orders that mandate the CDC requirements in large part in terms of for schools to reopen in that state, including mandatory masks for staff and for most students in most places in the schools. To the extent that states do not mandate those criteria through their state reopening school plans, there are also state public sector health and safety workplace laws, many of which are modeled on the Federal Occupational Safety and Health Act. 26 are modeled on that act, which is the federal workplace safety law that applies to private sector workplaces. And these 26 OSHA plan states follow the federal model, and among other things, they impose a general duty on employers to provide work and workplaces free from recognized hazards. They have a process for developing specific workplace safety standards that are enforced by the agency, and they have an administrative inspection and enforcement scheme. Just this week, Virginia became the first state in the country to adopt an enforceable workplace safety standard addressing COVID-19, which provides a mechanism for enforcing the CDC requirements in Virginia schools to some extent. And Oregon has announced that they intend to adopt a COVID-19 standard as well. So so you can see where your state stands. The blue states on this map are the OSHA plan states that follow the regulatory model I just talked about. And the light blue states on this slide are states that are not OSHA plan states, but they are states that follow the OSHA model as a floor, or they follow the regulations at least in part. These light blue states are states that have their own public health and safety law. It's a different model than OSHA, but there are protections there for public health and safety in the public sector. And the white states on this slide are states that do not have a state statute on health and safety for the public sector, meaning in public schools and public colleges and universities. But they do have common law tort liability, which means that employers in those states, including schools and universities, must take reasonable steps to protect people in their operations, and if they do not, can be held liable in court. And of course, and Dale and Marcy are going to delve into this more deeply, there are 34 states plus DC that protect bargaining rights, and those bargaining rights include the right to bargain over health and safety issues, bargaining agreement provisions on health and safety in those states will often be the strongest vehicle for enforcing the expert recommendations for health and safety in school reopening and campus reopening plans. And you should always remember the right to tenure protects educators who speak out from being fired without just cause, so that effectively provides educators with whistleblower protection so that they can speak up and advocate for safe school reopening. So I'm going to pause there before I turn this over to Kira and for a couple questions that have come up from many people in the last couple weeks.
Hi, Alice. I'm going to pose a couple of questions to you that have come up. The first is, you talk quite a bit about the CDC standards, but aren't those about to change? And if they do change, what protections will educators have?
So there has been a lot of pressure on the CDC for quite a while from the White House to change or modify the guidelines to some extent. The CDC has said that they do not intend to change them, that they will only supplement them. And so we continue to support the CDC. But the advocacy here is critical to make sure that the recommendations of the CDC as they stand now and the recommendations of experts are embedded into school reopening plans, into state reopening plans, so that they are enforceable and can protect our members and students in the schools.
Okay, another question. We've seen that both Trump and Betsy DeVos have threatened to withhold federal funding if schools don't reopen 5 days a week. Can they do that?
No, they cannot. And they came out with this threat maybe a week ago, and it's pretty much been roundly rejected by everybody. First of all, the federal government only provides approximately 10% of school funding in this country. And the funding that flows from the federal government under the IDEA and under ESSA flows pursuant to statutory requirements set by Congress. The president and DeVos do not have the authority to rewrite those statutory requirements. And if they did, they would certainly be sued. We would be first in line to do that, and we would surely win. I think what they are doing is they are trying to set up debate over the issue in the next round of COVID funding. But we will continue to make sure that they don't bully states or school districts into reopening and force people back to schools that are not safe. So we don't have time to go further on those subjects. I am going to turn this over to Kira, who's going to talk to us about accommodations and leave issues. Kira.
Thank you so much, Alice. I'm Kira McNett, NEA Staff Counsel, and I'm going to talk about accommodations and leave. Looking at the many questions we received, so many of you had concerns about your specific circumstances that may make in-person instruction more risky for you or for your family. And while everyone's individual situation is different, of course, there are some general categories we can talk about. And the ones I'm going to cover today are having a medical condition that increases the risk of serious illness or death from COVID-19, living with an individual who's at high risk, older age, pregnancy, and childcare responsibilities. The good news is that you have rights. There are individual rights under various employment laws that may apply, and I'm going to go over the federal laws that are listed here today, especially focusing on the first one, the Americans with Disabilities Act, but I'll also touch on the other federal laws that are listed here that may apply to some people's circumstances. And it's important to keep in mind that states and even some local level laws may provide more protections than the federal law. You may also have collective bargaining agreements or MOUs and school district policies that apply to your specific circumstances. So it's always important to check with your local and to consult with legal counsel at the local and state level on any individual questions that you have. As we're hearing from many members, a lot of people have health conditions that they may never have previously found disabling, that they were able to manage and do their jobs without even thinking about. But in this pandemic, there are many medical conditions that may present real challenges for returning to classrooms, depending on where things are at in your particular community and school. And if you have a health condition and you want to know whether you may qualify for an accommodation under the Americans with Disabilities Act, the ADA, the first question is whether your condition qualifies as a disability. And to be clear, disability here is a legal term, not a medical one. Under the ADA, it is defined as a physical or mental impairment that substantially limits one or more major life activity. And what qualifies as a disability is interpreted quite broadly. While we may ordinarily think about a disability as being some major permanent condition, under the law, it's something, it can also be something that's relatively minor and transitory, meaning it only lasts for, say, several months. So with that in mind about how disability is defined under the ADA, we look at the medical conditions the CDC has recognized as being known to increase the risk of severe illness from COVID-19. And you can read the list of conditions yourself here, but looking at all of the guidance from the EEOC, that's the Equal Employment Opportunity Commission, and court cases on ADA disabilities, all of these conditions may well be considered disabilities under the law. I've highlighted obesity here because there is some question about whether obesity alone will be seen by a court as a disability. So this is something where you want to think about whether there may be other physiological causes of a disability. But at the very least, if you fall into this high-risk category of a BMI over 30, you may have a basis on which to at least request an accommodation. The CDC also lists a number of other conditions that may increase risk based on what is currently known. And I've highlighted pregnancy here, which we'll discuss in a minute, and also smoking, because that's the only other thing on this list that would not potentially be a disability in and of itself. In addition to all of these conditions listed by the CDC, there may be other conditions as well. And it's also important to note that the ADA covers both physical and mental impairments. Many people are experiencing high degrees of stress related to COVID, but for individuals with certain diagnosed mental health impairments, it may cause particular difficulties and require accommodations to your work conditions. So if you have a health condition that seems to qualify as a covered disability under the ADA, what does this mean? The ADA requires employers to provide reasonable accommodations to qualified individuals with disabilities unless providing an accommodation would be an undue hardship on the employer. And a reasonable accommodation means some kind of modification to the job or to the work environment that will enable the employee to continue to perform the essential functions of their job. When we talk about accommodations, especially in the context of this pandemic, it involves a number of different interrelated factors. At the top of the diagram here, you have the essential functions of the job. And that's going to vary from job to job, and perhaps depending on how the school is being conducted, about how a return to school is being conducted. Then you look at what types of exposure to the virus you may have in your job and how those exposure points may interact with your medical condition. And then in considering what accommodations may work, you're thinking about how to reduce the risk based on the types of exposures you may have, and again, your medical condition. And back to the top of the diagram, whether these accommodations, the modifications to the job or to the work environment, will allow you to carry out the essential functions of your job. And the overall point here, sorry, Alice, if you could just go back for a second. The overall point here is just that the ADA accommodations question is really an individualized determination that looks at your full medical condition. And on the right, we have listed some of the accommodations that are possibilities based on what the CDC has recommended for risk reduction. And I just want to highlight briefly temporary leave here, because asking for open-ended leave as an accommodation is almost always a problem in ADA cases. So even though there's a lot of unknowns about how the pandemic is going to evolve, it's best when asking for an accommodation to put any request for leave in terms of a time frame. You could say, for example, until certain safety conditions are met, or until community transmission drops below a certain level. And next slide, please. So as far as how you go about requesting an accommodation, next slide, please. First, when you want to request an accommodation, you definitely want to check with your local association or your state affiliate, as they may be able to help you. And I'm going to give Alice a second to advance the slides here, but it's pretty common sense. Under the ADA, you can request an accommodation at any point that you may need one. You don't have to use any magic words, and you don't have to put the request in writing, but it is always a good idea to follow up in writing for your own records, and if for no other reason. And just one quick note here is we're seeing this in some places where school districts are sending surveys specifically asking employees to identify whether they have particular medical conditions. Some of the kinds of medical inquiries that are being made by employers in those surveys may be prohibited under the ADA. So if you're not requesting an accommodation, your employer can't require you to disclose your health conditions. And it may not be in your interest to volunteer that information unless you're specifically asking for an accommodation. So I think we're going to restart the slide deck here, but I can continue. You know, a lot of these are things that, you know, you'll see on the slide deck later when we circulate that. And so I'm just going to talk through those, but people—
Yeah, why don't you talk through them, Kira? I'm going to work on the slide deck. So just
no worries. I figured as much. People often ask what kind of medical records they need to provide. And you don't really have to provide medical documentation up front when you're asking for an accommodation. But if your employer asks for medical records, you should try to provide what is requested as long as it is relevant and necessary to demonstrate your particular disability. So, you know, going back to the kind of accommodations diagram that we were looking at, when you're talking to your medical provider, they really need to understand what it is you need in order to do your job. What does your job require? What modifications may be possible? And it's really important to getting a helpful note from them to make sure that they understand those things and that your medical provider can write you a note that explains what it is that you need. And I'm gonna just kind of continue here to talk through these things again. You know, the slide deck will be available after the presentation. So when you want to go back and see something other than just my talking head, you will have that. Once you've asked for an accommodation, now the employer has to do something to respond. They're required to consider the request, and they're required to engage in what the EEOC refers to as an interactive process, where the employer and the employee work together to try to find an appropriate accommodation. Ultimately, the employer just has to provide a reasonable accommodation. It doesn't necessarily have to be the one that you asked for. And keep in mind that the employer can claim that an accommodation isn't possible because it would be an undue hardship, but that's on them to show. So that's not something that you need to initially be concerned about. That's a defense that has to be raised by the employer, that it is an undue hardship for some reason. Once you make your request, oh, yay. All right. We're back. Next slide. We're past medical documentation. We're past talking to your medical provider. And what do they have to provide? We talked about that, about undue hardships. And the next slide that we're on is what to do if your request is denied. So great. Thank you, Alice. If your request is denied, it's a good idea to get more information about why and to try to fix the problem if you can. Especially if you're told that it's an undue hardship to provide it, ask for more details about why that is and try to discuss possible alternatives. You should report any denial of accommodations to your local, but also be aware that this is an individual right that you have under federal law, and there are strict time limits in which you have to bring claims if you want to file a complaint with the EEOC or with a state agency. And finally, it is illegal for an employer to retaliate against you for seeking an accommodation. So if you find you're being treated worse than other employees or any actions are taken against you after you make a request, be sure to object to this, report it to your local, and consult with legal counsel about filing a complaint. So in addition to the health conditions we've discussed, many members are worried about their risks if they're older, and the CDC notes that the risk of severe illness increases with age. However, age itself, if there's not also some underlying health condition you can point to, is not a disability, so there would not be protection under the ADA. The federal law that prohibits age discrimination doesn't have an accommodations provision like the ADA, but it also doesn't prevent employers from accommodating older workers. So that's something to be aware of, that the EEOC has made clear in its guidance on COVID that employers can voluntarily accommodate older workers and that wouldn't violate the Age Discrimination Act. Pregnancy is another issue that's come up a lot in thinking about members who may need accommodations. And as I noted before, pregnancy itself is not a disability, but many pregnancy-related conditions are considered disabilities. And this is a place where state law can be really important. I think the current count is that 29 states, DC, and 4 cities have their own pregnancy accommodation laws. So if you're pregnant and worried about the risk of exposure from COVID, you should talk to your medical provider about what accommodations are recommended for you. This one, I live with someone who is high risk, is a question we see so much. And so many people want to know what to do if they're worried about being exposed to COVID at work and then exposing a spouse or a parent or a child who may be at high risk. Unfortunately, this is an area where, at least under federal law, at least under federal law and state laws we've reviewed, there aren't many protections. Last slide, please. The ADA doesn't require an employer to make any accommodations for an employee to protect a family member with a disability. Under the ADA, you can't be treated worse or harassed because of your association with someone with a disability, but accommodations just on the basis of having a family member who's disabled, that's not something that's required under the ADA. So the FMLA may provide an option of taking unpaid leave, but only if you're caring for a family member who has a serious health condition, as that's defined under the FMLA. And I'll talk about these other laws a little bit on a slide, a few slides later, but in some limited circumstances, there may also be an option for paid leave under the Families First Coronavirus Response Act, which provides temporary paid leave through the end of this calendar year. So if you were caring for someone that you live with who's under quarantine, you may be able to apply some of that leave. Or if you're taking care of a son or daughter whose childcare provider is not available, you may qualify for expanded FMLA under this new law. And this would also apply if you're caring for an adult child who has a disability that makes them unable to care for themselves and whose regular care provider is not available because of COVID. Really though, this is an area where you particularly want to talk to your local and talk about what is and isn't part of a reopening plan that takes into account the needs of employees who have someone living with them who's high risk. And this next issue we're going to talk about is childcare responsibilities. This came up so much in the spring, and it will likely be a major concern again in the fall, particularly in areas where there's a hybrid model of online and in-person learning. As I said, there's this federal law that, at least until it expires at the end of the year, provides for paid family leave for the limited purpose of caring for a son or daughter whose school or daycare is closed due to the pandemic. And the emergency FMLA expansion provides a total of 12 weeks of leave, 10 of which is paid at 2/3 of your regular rate of pay. And I won't get into the details about the FFCRA because there's actually another full webinar on this leave. And it's available along with frequently asked questions on NEA's website, Educating Through Crisis, which you see at the bottom of the screen here. One important note is that you may be able to use this childcare intermittently. And that's something that has to be negotiated with the employer on a case-by-case basis, but it can be really important as an option for educators who are trying to juggle work and childcare. And just briefly, I'll touch on what your options are if you can't be accommodated. Again, just to highlight the FFCRA leave here, because it includes emergency paid sick leave for certain things related to coronavirus. And it can be used before you use any other leave. This leave applies to all employees, regardless of job classification and no matter how long you've worked for the employer. And then just another reminder about other options for leave, the FMLA, if you're covered under the federal law or under your state's FMLA law. And of course, consult with your local or with your state affiliate about leave you may have under an agreement with the employer or their policies, including possibly disability leave provided by state law or through your employer. The leave options we've already discussed may be available if you're exposed to COVID while working, depending on the severity of the symptoms when it comes to using FMLA or other sick leave you may have. In addition, the FFCRA would be available if you're under a government quarantine or isolation order, or if you've been advised by your doctor to self-quarantine, or if you're experiencing symptoms of COVID and you're trying to get a diagnosis. But again, this is only for a total of 80 hours. And unfortunately, that's not 80 hours every time you need it. It's a total of 80 hours. one question that we got many times was, what happens if I contract COVID at work? Are my medical bills and leave covered by workers' compensation? And it's true that workers' comp is where employees are ordinarily expected to go if they're injured or become ill because of something in the workplace. Whether you may be able to get workers' comp, though, is going to depend on state law. Workers' comp is a state program. And in general, as things stand in most of the country right now, it is sadly often difficult to get coverage for exposures at work, exposures to COVID at work. But this is an area where state laws and policies are evolving really rapidly. So definitely check with your local if this comes up. And if this is an issue that you're concerned about, there are probably discussions being had at your state level that you want to be a part of. In general, some practical guidance on workers' comp claims. First, you definitely want to notify your local if you contract COVID at work. And the other big point is to be aware that causation is usually going to be a strongly contested issue when it comes to COVID. So it's a good idea to document as much as you can about, for example, any previous COVID test results you've had, the limits of your non-work contacts, any possible sources of workplace exposure, and of course, medical details like when symptoms started. And you should definitely consult with legal counsel who knows your state workers' comp law. And with that, I'm going to turn it over to Jason Walta.
Thank you, Kira. I'm Jason Walta. I'm the NEA Deputy General Counsel, and I'm going to talk to you about whether schools can require educators, students, or the public to waive claims of liability for contracting COVID at school. Many of you sent us questions about this for the webinar, and it's an issue that's been a hot topic of discussion as we contemplate a reopening of schools. In fact, we have already seen a few instances of schools trying to use waivers like this. One school was asking teachers to sign a waiver that released the school from liability if the teacher contracted COVID at work, and it would waive the school's liability if any of the teacher's family members contracted COVID from the teacher. Elsewhere, we have seen what you see on your screen right now, and this is schools trying to insulate themselves from liability by posting notices in public. Here's one that's directed at the public attending a school event in Montana. I'll save all of you trying to read that wall of words there. Basically, it warns of the risks of contracting COVID and tells attendees that they have assumed those risks by remaining at the event. So the question is, can schools use these waivers and notices to release themselves from liability to those who contract COVID at work? And can educators be required to sign them? For school employees, we think the answer to both questions is no. These waivers are not effective and they cannot be required as a condition of work. And there are several reasons for this. The first is that workers' compensation would likely provide the exclusive source of recovery for a teacher who contracts COVID at work. And it is absolutely clear that employees cannot waive their workers' compensation rights in advance. Second, notwithstanding any workers' compensation laws, you are generally entitled to sue an employer that intentionally injures you. And it is against public policy to have advance waivers for those kinds of intentional harms. Third, you cannot waive the rights of other people, whether they are adults or in just about every state, children in your family. Fourth, to the extent your state has laws that regulate workplace safety, the kinds of laws that Alice was discussing, your protections under those laws cannot be waived. Fifth, if you have a disability protected by the ADA or state anti-discrimination laws, you cannot be required to waive those rights to protection and accommodation of your disability. Sixth, for tenured teachers, you can't be required to modify your employment contract on threat of termination. And finally, for states where you have collective bargaining, a school is generally prohibited from unilaterally changing the working conditions of educators without first bargaining with the union. So what about those notices posted outside of a school? Those wouldn't be any more effective against a teacher than a signed waiver, and I've just laid out all of the reasons why those signed waivers are improper. But notices directed toward the general public or possibly students, do they do anything? There the answer is a little more complicated. For students or members of the public, their legal recourse against a school for contracting COVID would likely be a tort claim, like a negligence claim. And even without a waiver or disclaimer, schools often have immunity under state laws for those kinds of claims. Still, schools can't use liability notices against students because those students are usually minors and they're legally obligated to attend school. They don't really have a choice about whether to assume risks or not. But schools might be able to limit some of their liability to other members of the public, assuming they saw the notice and accepted the risk. This would be a highly case-specific question and would be difficult to answer without knowing all of the circumstances. At the end of the day, these waivers are not likely to be effective in most circumstances, especially when it comes to educators. And that's why employment side lawyers that represent school districts are recommending against them. These lawyers have noted how waivers can backfire against employers or have unanticipated consequences. For one, they could discourage employees from returning to work. And second, they could create very bad publicity. So what should you do if presented with a waiver like this? First, immediately notify your local association and UNICERF director. You are the eyes and ears on the ground for this issue. Second, do not sign a waiver without consulting with your local association first. Finally, work with your local association to publicize the school's acknowledgement that it can't ensure a safe workplace or learning environment. Now, I believe we have some questions to field about individual employee protections and employer liability. Alice.
We do. So Kira, we have lots and lots of questions from members who are asking for whether or not they are entitled to work remotely as a matter of federal ADA law. Do they have a federal right to work remotely? And that's just, I just want to put aside, you know, we talked earlier about the advocacy at the state level and also at the local level to have a categorical exemption for at-risk folks in school reopening plans. But if there isn't one of those, do people have an individual right to work remotely?
So Alice, that's a tough question. And it's going to depend a lot on specific facts. I think there may often not be an easy answer, but it certainly doesn't mean that people shouldn't ask for remote work if that's what they need as an accommodation. If that's what you need, you should ask for it. And as you noted, Alice, that is something that the CDC recommends for certain high-risk individuals. So that's certainly something powerful to point to. If you're in a district where remote work is already known to be a possibility, it's just a matter of determining with your medical provider whether this is a recommended accommodation based on your medical condition and your job requirements. But if, for example, you're a teacher and your district is saying that everyone has to go back to in-person instruction, you get into some difficult legal and practical questions. And the main one is being physically present an essential function of your job? I think, as we all agree, remote instruction is not what anybody wants. But last spring, almost everywhere in this country, remote instruction was the norm. And now if a district is saying that being in person is a requirement, an essential function of the job, that can put employees who have needs for accommodations in a real bind. So I don't think you have to take an employer at their word that being in person is an essential function, given what we've seen in the history last spring. But depending on the circumstances in your community also, there may be a high number of not just other staff, but also students for whom conditions are not safe for them to be in the classroom and who need a remote learning option. So all of this is to say that this is an area where you really need to speak with your local. And I would also say, you know, it's important to involve legal counsel early on these kinds of questions that may come up about the ADA or what state disability accommodations laws may provide.
Great, thanks, Kira. Jason, a number of folks, you've already addressed in your remarks what protection individual employees have if they were to contract COVID at work, that their remedy would be a workers' compensation remedy under most circumstances. But what if somebody comes home and brings a virus home with them to a loved one, to someone in their family who gets sick, perhaps very severely sick? what liability would the school district or institution of higher education have?
Right. So, right. If an educator herself gets sick, you would look to workers' compensation. But if an educator's family member came down with COVID, contracted it from the educator who contracted it from school, that family member wouldn't look to workers' compensation. Instead, that person would look to remedies under traditional tort laws like negligence. But as I mentioned earlier as well, many states have immunity laws and liability protections for school districts that could make such claims difficult to prevail on.
Thanks, Jason. Kira, another one for you. We have lots of questions about if I'm ordered to quarantine or self-quarantine, and these are lengthy periods of quarantine, 14 days, because a student in my class has COVID or a colleague has COVID. What leave is available for that? And does the employer have to give me paid leave?
So, we talked about the emergency paid sick leave under the FFCRA, and that is the leave that you want to look to first if you're required to quarantine in this type of circumstance. But, what if you've already used this leave? I think all of the examples you've given, Alice, indicate that there are many different ways that a need for this leave could come up, and could come up multiple times for the same person. You could have multiple positive tests that require you to quarantine, meaning multiple times of students who test positive and you're told by the employer you need to go home. Beyond your right under federal law to the 80 hours of leave under the FFCRA, you really need to go to your local to find out whether these leave issues have already been discussed and agreed upon with the employer. And if there isn't already an agreement in place on leave to quarantine, these are questions that, I think you and your fellow staff need to be asking again and again and again. These questions for school districts of when and how they're going to require staff to quarantine when there are positive tests in the school community, and how staff are going to be able to use leave if they may have been exposed. These are really crucial considerations from a public health standpoint. That was the point of having emergency paid sick leave in the first place, is to allow people to protect their own health and to protect the community. So whether or not educators can stay home and take leave in order to do that, and not have to worry about pay and about being out of school for that period of time, these are really crucial considerations from a public health standpoint, for the ability of schools to continue to operate, and for parents to feel confident that there's a well thought out plan in place to keep students safe. So, if a district can't answer these questions, or if an institution of higher education can't answer these questions, this is a real cause for concern for everyone in the school community, students, staff, and parents.
So look for it to be addressed in your reopening plans. Everybody should make sure that's nailed down. Jason, last question on this segment is for you, which is this. If someone in my classroom or in my lecture hall contracts COVID, do I have a liability risk to them for teaching them under, a particular set of circumstances that I did not believe was sufficiently protective?
Sure. So in Alice, in that circumstance, the school would be the primary defender of the lawsuit, and they would be the one to pay damages in a lawsuit, as long as the claim is one that you as an educator caused some kind of harm while performing your duties. And also, as I said, there are state immunity and liability doctrines that could limit or make it more difficult for a student or a member of the public to prevail against a school or a teacher in those circumstances.
Great. Thanks, Jason and Kira. We are now going to move to Dale and Marcy to talk about bargaining and other advocacy strategies to make sure all these issues are addressed in your local agreements or policies. Dale.
Thanks, Alice. The NEA Collective Bargaining and Member Advocacy Department is staffed by experts in topics including pay, pension, health benefits, collective bargaining contract language, and policy guidance. We support affiliates and member needs, including those that don't have bargaining rights as well. From the outset of COVID-19, the COVID-19 pandemic, we've worked with NEA and local affiliates to provide guidance to respond to COVID-19 questions and help members on such issues as leave, hazard pay, health benefits, distance learning, just to name a few. In the next section, we will share with you bargaining and advocacy strategies that you can engage in your local association that can protect your health, safety, and security. And I'm going to turn this over to my colleague, Marcy Maggot. Marcy is one of our senior collective bargaining specialists, and she's going to talk about some of these strategies. Marcy?
Thank you, Dale. So as Dale said, I'm Marcy Maggot from NEA's Collective Bargaining. And as she said, we're going to be addressing the bargaining and advocacy approaches to health and safety under COVID-19. I know that many of you live and work in states that have bargaining statutes and some do not. I assure you our presentation is going to be relevant to everyone, but I'm first going to touch on the bargaining aspect of this. For states that are covered by the state collective bargaining statutes, and Alice mentioned there are 34 of them, most laws address salary, benefits, and working conditions. A healthy and safe workplace is obviously a major working condition. So for locals and states with collective bargaining laws, we recommend, and we did this before COVID-19, that you negotiate strong and healthy safe contract language. An example is on the slide. As you can see, this language is very broad, but provides a very strong baseline. If your contract is going to expire this summer and you want to strengthen or add some good language, you can use this as a model. You can also add more specific language. We urge you to work with your local to see if you can improve this section of your contract. If your contract is not going to expire for a while, your local may also want to negotiate a separate memorandum of understanding, or MOU, to cover health and safety issues under COVID-19. It depends on your local situation. New slide, please. So besides bargaining, there's another very important way to deal with health and safety issues, and that is to create a joint labor management health and safety committee. For educators in states without bargaining laws, it's crucial means to engage with management. Health and safety committees are very effective in bargaining settings as well. So a labor management committee can address the issues that everybody is confronting right now and that my colleagues have spoken about. On the screen, you'll see just a sample of them. Some of them are relatively technical in nature, such as developing the social distancing protocols, ensuring that staff and students have protective gear and ability to wash their hands, developing the procedures for disinfecting and sanitizing, and ensuring proper ventilation. But other issues and work can include working together to develop contingency plans on a number of topics, such as if students or staff contract COVID-19, or if schools or colleges have to open or close, be it temporarily or for an extended period. Or also making plans for students, staff, and families who may be at a higher risk from COVID-19. There are also some issues that are ongoing and complicated and long-term, such as ensuring that the employer is factoring in social and racial justice implications of any plan to ensure that all students are safe, and also to provide enhanced and comprehensive mental health supports for students and educators. Next slide. So the committee not only helps protect educators and students and their families, but also ensures that educators' insights are taken into account. The committee structure is also well suited to dealing with the fluid and constantly evolving nature of COVID-19. To establish a committee, a local can either add language to an existing contract or negotiate an MOU to establish one. Like contract language in general, you can either make it very broad or specifics in terms of process, the number of meetings, etc. Locals that do not have bargaining rights can use this contract language or other contract language examples as guidelines for school board or university policies. If you have an existing labor management committee, such as a wellness committee, you may want to repurpose it relatively quickly to address COVID-19 issues. The committee's membership should comprise all educators, all of whom are selected by the association. And we recommend that these committees are permanent While they may be focusing on COVID-19 issues now, healthy and safe schools should always be the norm. Next slide, please. So the main purpose of these committees is to monitor the health and safety conditions of the workplace. I'm sharing a few examples of the types of responsibilities that a committee may have. A key one is reviewing and monitoring different reports and activities, such as inspection and injury reports, and confirming corrective measures. In the COVID context, this could also include developing social distancing protocols and making sure they are being followed. The committee can also ensure that safe cleaning products, procedures, and equipment are used. Labor management committees should also take the lead in addressing what we are all dealing with now, what school is going to look like, whether it's in-person instruction or distance learning, based on the recommendations and guidance from the CDC, your state local health authorities, and NEA recommendations. Another example is that a health and safety committee can also be an effective means to develop district or school-wide communication plans. So all employees are aware of what's going on in their workplace on an ongoing basis and hearing the exact same message. Again, this is something that should occur beyond COVID-19. Next slide. We also recommend that locals consider creating a health and safety committee at every school or campus because conditions can vary significantly between schools or campuses. Again, this is true regardless of COVID-19. You could have ventilation problems in one building while everything is fine in another. There may also be different issues at an elementary or a secondary issue from a health and safety perspective. Last, we suggest that you consider involving students, older ones, and families and other community stakeholders on the committee. Students and families' perspectives are important and can be useful in identifying important health and safety issues. New slide, please. So the last issue I'm going to touch on is about whistleblower protections. Alice had mentioned that they can also be covered by tenure laws, but from a contract perspective, it's crucial for locals to bargain or advocate for whistleblower protections at the state or local level to guarantee that education employees are protected against retaliation or reprisals. Again, this is true in general, but it's especially important if they are raising or reporting concerns about workplace safety with respect to COVID-19. We recommend that in your next round of bargaining, you try to add such kind of contract language, if you don't have it, to strengthen your contract. You can also include it as part of the guiding principles of a joint health and safety committee plan. And if you don't have bargaining rights, try to establish it as a school board or university policy. There may be existing state or local safety, worker safety statutes or ordinances that may provide protections. So we recommend that you consult with your local association council. Last, you'll see on the slide a link to the National Employment Law Project's Guide to Developing Whistleblower Protections, which is an excellent resource. We suggest that you check it out. And now I'm going to turn the presentation back over to Dale.
Thank you, Marcy. Thousands of collective bargaining agreements around the country will expire this summer and will need to be renegotiated. It's a perfect opportunity to address the impact of COVID-19 on all the issues that have been discussed today. And where we don't have contracts expiring or the right to bargain, we can still bargain memoranda of agreements to address these issues or advocate for policy changes. In the past several years, NEA and many of its affiliates have engaged in powerful community-wide crusades, organizing and bargaining for public schools. In bargaining and non-bargaining states alike, parents, students, educators, and community activists have united to fight for everything from smaller class sizes and mental health supports to school safety, racial justice, and fair wages, and more. BCG, which is Bargaining for the Common Good, expands the scope of bargaining far beyond the contract to include non-traditional, student-centered issues. Initiating a common good campaign can address long-standing equity and health and safety issues that have been exacerbated by the pandemic. Next slide. Here are some examples of how BCG can be used to address the many issues affecting students and members as a result of the pandemic. You can involve parents and community members at the initial phases of the planning and decision-making on reopening schools and keeping them safe and critical. Engage students and their families to find out their experiences during the initial closures and intentionally seek details on how the racial and economic disparities affected education. Work with food service personnel and parents to determine the best and safest ways of implementing ongoing nutrition and food distribution for students. Next slide. You can seek additional school nurses, social workers, counselors, and other specialized instructional support personnel to support student needs. Seek to eliminate or limit foreclosures, eviction proceedings, and actions against children with school-aged children. Given the district regulations that students will face in this environment, institute restorative justice practices rather than punitive disciplinary methods. And those are just a few of the examples, and NEA will continue to work with our affiliates on this initiative. For more information on bargaining for the common good, you can either go to nea.org/BCG, and then further resources would be on our partners site, bargainingforthecommongood.org. And we work closely with this partner. Georgetown University's come out of its Institute for the Working Poor, and Rutgers University Center for Innovation and Worker Organization. And again, their site is included at the bottom of this slide. And with that, I think we have a couple of questions that have come in on health and safety, and I'm going to ask Marcy to answer them. We received many questions about specific health and safety provisions. And one example, if we go back into the classroom to teach, should we bargain for PPE, masks, wipes, etc.? And what about testing?
Yes, yeah, that's a great question. And as you said, we received many health and safety questions. In general, we recommend working with your UNISERV to draft contract language or an MOU to address return to school issues that comply with the latest CDC guidelines and your state health authority guidance. This also highlights the importance of having an active joint health and safety labor management committee, because the local and the employer can work together to address needs as they arise.
Thank you, Marcy. We have also received questions like this from members in non-bargaining states. I'm in a non-bargaining state. What specific measures can my local use to ensure that our school board and school district is looking out for the safety of students and educators?
Our OTC colleagues addressed some federal and possible state legal and regulatory protections. So your local and UNISERV should look into that. But as I noted in my presentation, many NEA affiliates in states without bargaining laws have found great success working with management and collaborative relationship in general, but specifically on health and safety committees. So if such a collaborative relationship doesn't exist, engaging members and building strong relationships with parents in the community can also be a powerful lever to help set and change policy. The bargaining for the common good concepts that you just discussed are another useful approach. The current COVID-19 environment is a clear case where schools must be safe for all educators, students, and their family. And it's helpful to work together.
Thanks, Marcy. We have time for one final question. And this question doesn't address health and safety directly, but it does show how nuanced these issues can be. Does remote learning or blended learning affect class size as it bargained in a collective bargaining agreement?
Yeah, this is a great question. Like many of the questions we've received, this question addresses specific working conditions at an educator school or school district. So the answer depends on the local context, including what's relevant in the collective bargaining agreement and existing state regulations and bargaining laws. So we recommend that the questioner consult with your local association and your UNISERV, but the question highlights the complexity of the issues that are coming up. And it's one reason why we recommend that locals negotiate MOUs to address the various locally based issues that are related to COVID-19.
Thank you, Marcy. And with that, I'm going to turn it back over to Alice. Thank you.
Thanks so much, Dale and Marcy, for your expert guidance on the bargaining issues and the advocacy issues. And thank you to Jason and Kira for your legal counsel on the accommodations and leave and worker compensation and waiver and liability questions. Again, just to remind everybody, for advice on your specific situation, always go to your local and your state affiliate, so because they can assist you. Always go there. I want to thank all of you for signing in for today's town hall and for submitting all your many, many questions. I hope you got some answers today on those questions. I want to remind you that there will be additional resources available. They will be on the Educating Through Crisis, that's educatingthroughcrisis.org site that NEA has up. You can find that guidance. We will also be emailing it out to everyone who registered for these town halls. I'd also urge you, I know a number of people in their questions wanted to connect with other educators in their particular job category or dealing with their particular group of students about strategies in the reopening context. And I'd urge you to check out the Facebook site, which is listed on the page. And for those on the phone, it's NEA Navigates COVID-19. As that's a site where you can connect with educators across the country on these issues. And I want to close with this. First, if and when we get the pandemic under control in a particular community, it is critical that schools and universities and colleges put the protections in place that the CDC and the experts have recommended as necessary to protect the health and safety of our students and our staff. And in order to do that, the federal government needs to provide the funding that the HEROES Act has in it. So again, if you have not yet reached out to your senator, if everyone in your family hasn't reached out to your senator, if everyone in your community doesn't know that we need the federal government to act in order to provide the funding so that schools and universities can reopen safely when it is safe to do so, let them know. Speak up loudly. I know you do that all the time. And let the US Senate know that they need to move. Finally, if you heard nothing else from us this afternoon, I hope you heard this. We are with you, we support you, and we will fight to protect you and your students and your rights to safe workplaces, safe schools, safe campuses, safe school buses, safe central offices. We are with you in this crisis. Thanks so much for joining. We will post the slide as well on the slide deck as well on the Educating Through Crisis site. And thank you for hanging in. Apologies for the technological glitches, but we got through them just the way we always do. Thanks again. Have a good afternoon, everyone.